associates of the bar, fellow colleagues, and students of the profession of law, I extend a very warm welcome to you all for your gracious presence in today's lecture, soon to be delivered by Senior Advocate Vivek Sood sir himself. Although any introduction of an expert in the field such as him with over 30 years standing at the bar will require more time than I have in my hand right now. Nonetheless, I will do what a young lawyer is best known for. I'll try my best. Sir, as an avid practitioner of business, criminal, especially white collar, tech, cyber, and constitutional laws, has a 3-decade-long litigation experience, wherein he has argued innumerable civil, criminal, commercial, and constitutional briefs, including criminal trials, writs, suits, appeals, revisions, constitutional challenges, and arbitration disputes. Through his appearances before the Supreme Court of India, Delhi High Court, arbitral tribunals, and numerous other forums, he has represented government organizations such as NDMC, Union of India, Ludhiana Improvement Trust, State of Haryana, the Chandigarh Industrial and Tourism Development Corporation, etc., and is continuously engaged by reputed law firms such as AZB and Partners, Dua and Associates, and private companies such as Amazon, ITC Limited, ITC Hotels, to name a very few, in several high-stake disputes. He has also been engaged in conducting central government litigation before the Supreme Court of India by Department of Legal Affairs. With being a counsel in over 500 reported judgments, and still counting, I believe, Sir seems to spend his time of leisure in writing. Through his 6 books, and a recently added one, Chaff and Grain, Sir has blessed this profession with his intellectual contribution on seldom discussed topics such as fundamental right to internet, cyber crimes, right to privacy, etc. And as an extension to the same, today he is going to enlighten us on the topic jail not bail, or bail not jail. Now, without further delay, I welcome Senior Advocate Vivek Sood sir on the podium.
Good evening to all of you. I can see my friends from the bar, law students, interns, youngsters. I will talk about this very interesting subject, bail not jail or jail not bail. Bail justice, in my view, is amongst the most complex areas of our criminal justice system. It looks very simple. Bail not jail, very simple. But I will demonstrate that it's a very complex subject, and I will try and demystify this subject. We will not be dealing with the normal parameters of bail, etc., etc. We will take the discussion to a higher level, to a more practical level, rather than the theoretical reading of case law, etc. I must start with a dilemma. There is a dilemma in bail justice. If bail is liberally granted to everybody, to every accused, then you will have many criminals roaming the streets. If you conservatively apply bail justice principles, if you deny bail to people, then you have cases where many innocents may languish in jail for years together, and ultimately they might be acquitted, which is a serious violation of human right. So this is a dilemma, and I will try and unravel this dilemma. First of all, what is the meaning of bail? Simple meaning of bail. Simple meaning of bail, the dictionary meaning, As per the Black's Law Dictionary, bail is a security such as cash or a bond, especially security required by a court for the release of a prisoner who must appear in court at a future time. Bail is basically, in essence, a security for the accused to appear in the court and face the trial. Wharton's Law, lexicon, to set at liberty a person arrested or imprisoned on security being taken for his appearance on a day and at a place certain, which security is called bail, because the party arrested or imprisoned is delivered into the hands of those who bind themselves or become bail for his due appearance, that is the surety, due appearance required in order that he may be safely protected from prison, to which they have, if they fear his escape, etc., the legal power to deliver him. Importance of the surety. The surety has control over the accused. If he runs away, if he jumps bail, he should be in a position to get him back into the prison. Simple meaning of bail. Now, however, in law, it's not as simple. It should not be as simple also, otherwise we lawyers will be out of business. If bail became so simple, the accused will not need us as lawyers. So we must keep the complexity alive. Okay. Now, what are the bail parameters? Just a glimpse of the parameters of bail, and then we'll get into the philosophical and the jurisprudential aspects of the dilemmas of bail justice. The first important parameter is the nature of offense for which bail is sought. In other words, the seriousness of the offense. The second parameter is whether the accused, who is likely to be released on bail, will influence witnesses. Is there a likelihood that he may influence witnesses or tamper with the evidence against him? The third important parameter is the flight risk. Will he face the trial or will he abscond? Very important parameter. The fourth important parameter for bail to under trials is whether the investigation is complete. Very often we argue in the court that the charge sheet has been filed. Now please grant me bail. Investigation is concluded. I will face the trial. Since investigation is concluded, there is no chance that I will tamper with the investigation. The fifth important parameter is the length of the trial, the expected trial. Very often we argue that the charge sheet has 150 or 200 witnesses. The trial will take a long time. So therefore, please grant me bail. Why should I be kept in custody for such a long time? And the sixth important parameter, there may be others also, the minor parameters, but these are the 6 important parameters. The sixth parameter is the length of custody. We often argue before courts that the man has been in jail for 6 months, 8 months, 9 months, 2 years. Bail should not be denied as a matter of punishment. So please grant me bail. So these are the 6 important parameters for grant or rejection of a bail application in the court of law. Now, amongst the 6 parameters, I started with the seriousness of the offense. I started by saying that seriousness of the offense, the nature of the offense, is a significant factor when it comes to grant of bail. I find that this parameter of seriousness of the offense is grossly misunderstood by lawyers and judges. Very frequently we are arguing, a client comes to us. The first question, what is the offense? Either 302 murder, arey nahi hogi bail. Or you stand up in the court, what is the offense? 302. No, please, why don't you move the High Court? The Sessions Court will say. You go to the High Court is ever willing to adjourn 302 bail applications. Seriousness of the offense has assumed undue importance in our criminal justice system. And I will demonstrate that. In my view, and I will fortify my view with judgments also, seriousness of the offense per se is not a ground for rejection of a bail application. It is only one of the relevant factors. Very often the seriousness assumes all importance in a bail application, but that is not the law. Seriousness of the offense is a relevant factor to arrive at the conclusion whether there is a flight risk. Now kindly understand, kindly appreciate, the offenses of murder, a gruesome murder, which may invite death penalty if the prosecution is able to prove its case beyond reasonable doubt. Now because the accused may be visited with death penalty and the offense is gruesome, serious, and there is a lot of evidence against him. Eyewitness account is there. Recoveries are there. It looks like an open and shut case. Gruesome murder, brutal murder. Therefore, the accused is likely to abscond and run away. So therefore, seriousness of the offense is a relevant factor to decide whether there is a flight risk or not. But suppose he is a respectable member of the society, suppose he has roots in the society, suppose he has a house, he has a certain place of residence, he has a family, he has a business, he is embedded in the society. Therefore the flight risk is not there. So the flight risk, the risk of running away is diluted with the man being embedded in the society. So therefore the seriousness of the offense will shrink into insignificance in my view in the grant of bail. But the system, the criminal justice system looks at seriousness of the offense as a very, very important factor or the sole important factor in the rejection or grant of bail, in the rejection of bail. Seriousness of the offense is also a factor that may impel or that may induce the accused to influence the witnesses. Very frequently we come across cases in the newspapers that the witness has been killed. Recently also we came across some case in UP. The witness has been killed. Because of the seriousness of the crime that may invite life term or death sentence, the accused is desperate. In that desperation, he may influence the witnesses, threaten the witnesses. He may kill the witnesses. So therefore, it is again an important factor. Seriousness of the offense is an important factor to determine whether the accused is likely to tamper with the evidence and influence witnesses. Or the seriousness of the offense may also lead to a propensity to repeat the crime. A man is a gangster. Suppose there is a supari killing. It's not one of those sudden fights where the man was killed. In a supari killing, in an organized crime, there might be a propensity of the accused to commit further crime. So seriousness of the offense is only a relevant factor and not conclusive at all. If the accused is able to show that he is not a flight risk, there is no propensity of his committing the crime again, he is not likely to influence witnesses. If he is able to show, why should he be denied bail, is the question. But then the criminal justice system does not go into the depth of this aspect of the matter. It is dealt with at a very superficial level. 302 का label है तो bail deny him bail. Now I'll just cite an example where seriousness of the offense was given overimportance. I'll give you some examples. Let's take the example of the 2G spectrum scam case, Sanjay Chandra and others. In my view, all the accused, Raja and Kanimoi and all of them, Sanjay Chandra, they fulfilled all the parameters for the grant of bail at the very beginning. How? They were not arrested during investigation. It means they cooperated in the investigation. They didn't run away from the country. There was no flight risk. They cooperated in the investigation. Whenever they were called by CBI, they joined investigation. All of them had roots in the society. They had permanent places of residence, business, position in society. The entire case of the prosecution rested on documentary evidence. So there was no question of influencing witnesses, tampering with the evidence. The flight risk could have been reduced to zero if their passports had been impounded or kept as a security. So in my view, bail was denied to the accused in 2G spectrum case. In my view, I'll come to this later also, as a matter of punishment. I'll come to this aspect later when I deal with Satinder Kumar Antil's case, Supreme Court, 2022. It is a settled principle that bail should not be denied so as to punish the accused. Now, what do you mean by this? What is meant by this? Whenever the seriousness of the offense is given overimportance in a case, offense looks very serious. So therefore, bail should be denied to the accused. In any case where seriousness is overplayed by the judges, it means bail is being denied so as to punish the accused even before the trial has begun. This is what is the meaning of this concept. When other factors for grant of bail are overlooked and too much importance is given to the seriousness of the crime, it means bail is being denied so as to punish the accused even before the trial has begun. Let me explain this principle a little differently. As per the fundamental tenets of criminal jurisprudence, every accused is entitled as a human right to the presumption of innocence. There may be some exceptions. We are not talking of the exceptions. Let's take the case of murder, rape, kidnapping, all IPC offenses. It means that every accused is presumed to be innocent until proven guilty in a criminal trial. Secondly, the prosecution must prove its case beyond reasonable doubt. The Blackstonian principle. 10 guilty men may go scot-free but not one innocent man should be punished. Therefore, when you apply these principles to an accused, and when bail is denied, so as to punish the accused, on applying these principles, these three principles, it means you are keeping an innocent man incarcerated in jail. He enjoys the presumption of innocence. Prosecution has the onerous duty of proving the case beyond reasonable doubt. Blackstonian principle. So you are going against these three principles and denying bail to the accused before the trial has begun. Now the importance of seriousness of the offense has been highlighted in a very interesting judgment. I will request you all to read this judgment. It's a judgment by Justice Krishna Iyer, Gudikanti Narasimhulu, 1978, 1 SCC, page 240. I will read two paragraphs from this judgment. Justice Krishna Iyer, sorry. Repeat the citation. 1978, 1 SCC, that is Supreme Court cases, page 240. And Justice Krishna Iyer says, what is often forgotten, very important words, said in 1978, still we have forgotten this. We have not understood this even now after 50 years. What is often forgotten and therefore warrants reminder is the object to keep a person in judicial custody pending trial or disposal of an appeal. Lord Russell said, Chief Justice Lord Russell said, I observe that in this case bail was refused for the prisoner. It cannot be too strongly impressed on the magistracy of the country that bail is not to be withheld as a punishment, but that the requirements as to bail are merely to secure the attendance of the prisoner at the trial. Simple. I started by saying that. What is the meaning of bail? Ultimately, the essence is to ensure that the accused faces the trial. Then he goes on to say, it was the duty of magistrates to admit accused persons to bail wherever practical, unless there were strong grounds for supposing that such persons would not appear to take their trial. It was not the poorer classes. Now very important, most of the time poorer classes are denied bail. It was not the poorer classes who did not appear, for their circumstances were such as to tie them to the place where they carried on their work. A poor man, where will he run away? Where will he disappear? He'll be working in some mine or some place for his livelihood. They had not the golden wings with which to flee from justice. Poor people don't have golden wings to fly away in their chartered planes like Nirav Modi, etc. They are tied to their circumstances. Then, in Archbold, it is stated, the proper test of whether bail should be granted or refused is whether it is probable that the defendant will appear to take his trial. The basic principle. Now, very important. The test should be applied. The test means the test whether he will appear or not to face the trial. The test should be applied by reference to the following considerations. Not just make a list of those parameters, seriousness of the offense, bail rejected. The nature of the accusation, whether he will come and face the trial, probability depends upon the nature of the accusation. The nature of the evidence in support of the accusation. the severity of the punishment. These are the three parameters to decide whether he will come and face the trial or not. Or is he a desperado who will run away and flee from justice? Then it says, in this perspective, relevance of considerations is regulated by their nexus. All these considerations of seriousness of the offense, etc., fleeing from justice, they have a nexus, if such a plausible in the case. In this perspective, relevance of considerations is regulated by their nexus with the likely absence of the applicant for fear of a severe sentence. Ultimately, will he face the trial? Is the essence of bail. If yes, he should be granted bail, irrespective of the seriousness of the accusation. Now, with this background, with this platform that we have created, let us come to certain species of cases. Let's take murder cases as an example. Unfortunately in the Indian criminal justice system, all the accused in a murder case are painted with the same brush of bail denial. 99.9% cases, bail is denied to murder accused. Now, in my view, what is the solution? I come back to the dilemma. If bail is liberally granted, you may have criminals roaming the streets. If bail is unjustifiably denied, you have innocents incarcerated in jail forever. Dilemma. In my view, judges and lawyers, we must classify the accused, first of all. For example, you must have seen many bystanders are also made accused. The fight was between X and Y. Y perished in that fight. Maybe stab injury or gunshot or something like that. Or a brick was thrown on his head or something happened. Very frequently, bystanders, relatives and friends of the accused party, of the main accused, are also implicated. And common allegation, exhortation. इसने बोला मारो साले को, इसने बोला खत्म कर दो इसको. These are the allegations made, and many of these bystanders are made accused. Now you will find many judgments of the Supreme Court which say that allegations of exhortation are generally false and they are made to falsely implicate as many people who are close to the main accused. Now when you have such a principle that it's a weak allegation, exhortation is a very weak allegation. The real case of exhortation would be that I exhort somebody and based on my exhortation that man is killed. It's not exhortation. मार दो इसको, खत्म कर दो आज, इसको जाने मत देना. These are the normal dialogues you will find. As if all those witnesses are having some telepathy with each other in different cases. Even the dialogues are the same. You will find them to be the same. खत्म कर दो, मार दो साले को, जाने मत देना, आज बस सब खत्म कर दो, और all that. Common allegation. Grant them bail. Bail is not granted to them. Just because the label 302. Then we all know many conspirators are falsely implicated or they are weakly implicated. By weakly implicated means there is weak evidence of conspiracy. He was in touch with that man, conspirator, 120B. 120B, by the way, was a very colonial legislation made by the Britishers to bring in everybody, to huddle everybody as an accused, even abettors for that matter. Grant them bail. Unless he is the kingpin. He has given that supari. Unless you have that kind of credible material against the accused, grant bail to these normal conspirators. You very frequently I find in murder cases, so many people are implicated as abettors. Section 34, common object, common intention, 148, 149, 120B. Grant them bail. Then, many cases are such where the prosecution alleges that there was a fight between the two and one of the persons died. Where a case prima facie appears to be a case of a sudden fight or quarrel without premeditation, no weapon used, some brick was thrown at the deceased, or some kitchen knife was used, or he was bashed so badly, and there is some element of suddenness in the quarrel or a fight, and no premeditation, and the case may end in 304, part 2. No intention. Grant him bail. Where even ultimately if he is convicted, I have come across cases where such people are punished with 4 years, 5 years, 6 years. Grant them bail. Why keep them in jail? Now, I come to the main accused. What should be the bail strategy? After all, you can't keep people incarcerated forever. After all, bail not jail, presumption of innocence, Blackstonian principle, proof beyond reasonable doubt. All these factors are important. So what should be the bail strategy for the main accused in murder cases? Now, some of those strategies should be, in my view, judges should be more creative. When you see that there are so many witnesses in a case and the trial will take a long time, but the crime is gruesome, brutal murder, dilemma. On one hand, indefinite trial, on the other hand, brutality. Maybe apply the principles of parole, for example. Normally parole is granted only to those convicts who have been convicted by the court below, and in the appellate court also they have lost the appeal. Now parole, normally it is granted twice in a year, and for some reason, maybe marriage in the family, birth in the family, death in the family, घर को ठीक करवाना है, for repairs of the home, or for restoration of social ties and family ties. Apply parole, give him bail for 1 month, see his conduct for that 1 month. If he surrenders in time, after 6 months, give him another interim bail for 2 months. Test his credibility rather than assume that he is a flight risk. Give him another parole for 3 months. And if his conduct is satisfactory, grant him bail. Grant him bail. Now, I can see some green shoots in our criminal justice system. Indrani Mukherjee, 2021, granted bail in spite of a brutal murder of her own daughter, destruction of evidence. She was granted bail by the Supreme Court as she had spent 6.5 years in jail, and out of 237 prosecution witnesses, only 68 had been examined. Deholds the seriousness of the offence, she was granted bail by the Supreme Court. But I find that Indrani Mukherjee is not percolating into the criminal justice system. I've been arguing, I've been relying upon Indrani Mukherjee in so many cases. But somehow that mindset is anti-bail in murder cases. That mindset refuses to change. We need many more Indrani Mukherjees from the apex court. In a lighter vein, in good humor, if you rely too much on Indrani Mukherjee, judges will say, you are not Indrani Mukherjee, that you should be granted bail. First you raise your level to being Indrani Mukherjee. Come on page 3 or something, then we'll see. It's like, very frequently I joke with my good friend Mr. Anuj Chauhan that, if you rely too much on Madhav Rao Scindia quashing, so then the judges say, you are not Madhav Rao Scindia. You face the trial. Okay. Now this situation of denial of bail, I feel there's too much discretion given to the judges. They're enjoying too much of discretion. And I will read some interesting passages from, again, Krishna Iyer's judgment in Gudikanti, Narasimulu and others. He starts by saying, bail not jail, bail or jail, question mark, bail or jail. At the pre-trial or post-conviction stage belongs to the blurred area of the criminal justice system and largely hinges on the hunch of the bench. Otherwise, this hunch of the bench, you must let's give it a good word, otherwise called judicial discretion. And then he quotes, Justice Krishna Iyer quotes Benjamin Cardozo, who says the judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight-errant roaming at will in pursuit of his own ideal of beauty or of goodness. Judges, in my view, should not get into reforming the society. Apply the bail principles, grant him bail, or they should not get into reforming society. बहुत crime बढ़ रहा है, so we must deny bail to everybody. He used to draw his inspiration from consecrated principles, not to innovate at pleasure, not his whims and fancies. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order in the social life. Wide enough of all conscience is the field of discretion that remains. Then Lord Camden, the discretion of a judge is the law of tyrants. Very well said. Law of tyrants. It is always unknown. We don't know what the judge is thinking. वकील साहब 4 बजे पता कर लीजिएगा order. And the judge has not asked you a single question during your arguments. No, you come out very happy. But see, my arguments have gone unchallenged. And at 4:15 your clerk will tell you, bail to dismiss हो गई, खारिज हो गई. So we don't know. It is unknown. It is different in different men. It is casual and depends upon constitution, temper and passion. In the best, it is oft times caprice In the worst, it is every vice. It is a vice. It is a folly and passion to which human nature is liable. This is discretion. This is how discretion has been defined by Krishna Iyer and these great judges. Now I'll just cite an instance. I'm arguing this case in the High Court. The man has been in jail for 12 years. His score, I call it the cricket score. Out of 78 witnesses, 46 have been examined in 12 years. So with this mathematics, the trial will take another 10 years. He's a conspirator, not the shooter. Bail is not granted by the Sessions Court. Matter is pending in the Delhi High Court for the last 1 year. It is just tossed to the next date. So Indrani Mukherjee and these principles are yet to percolate into the criminal justice system. The man was released on bail for about 1 year during the pandemic. His conduct was good. Grant him bail. Grant him bail. Okay. I come to another aspect of bail justice. Another dilemma. I have coined this expression in my recent book, Chaff and Grain. It is phenocide. I have coined this word phenocide in my book, Chaff and Grain. Like genocide, phenocide. In financial crimes where we have a large number of victims, like home buyers, large number of victims. In a genocide, large number of victims. In phenocide, large number of victims of financial crimes. Then you have trunks of documents, evidentiary documents. Trunks. You must have all seen these trunks in Tisazari and the trial courts. At least now in the High Court, those trunks are coming into pen drives and other small gadgets. But you see these trunk full of documents. Now in such a case, the trial is indefinite. I am doing this case, in Vigneshwara developers. I represent the Consumers Association. We have ensured that bail is not granted to the accused even after they being in jail for 7 years, 8 years. No bail. And these are open and shut cases. Let's understand. They must end in conviction. After all, if you promised a home to 200 buyers and you have not been able to deliver even one after 15 years, whereas the time frame was only 2 or 3 years, it's an open and shut case of cheating. You never intended to do it. It's not a case of delay. It's not that you are refunding the money. You have misappropriated the money. Money has been laundered. After all, the money should be there somewhere. Now, the dilemma. If the accused are released on bail, trial is in perpetuity. So no punishment at the end of it. Now in this Vigneshwara, the charge sheet was filed 5 years back. Even the arguments on charge have not begun. Over 500 witnesses, trunks of documents, not one trunk, trunks of documents. And the CMM's court or the ACMM's court, Saket, has about 120 matters listed every day. The moment the judge sees Vigneshwara or such like cases, तारीख दे दो, आयो नहीं आया, ये नहीं हुआ, something or the other has happened. He's scared to even touch it. But at the same time, incarceration forever without the trial starting is a gross violation of the human right to freedom, liberty. What is the resolution to this dilemma? The resolution, in my view, are twofold. We must have special courts like CBI courts for PC Act. You must have special courts trying cases of genocide where the number of victims are large. Trunks of documents. You must have courts so that the trial begins and it ends. See, problem is not only with respect to the main accused. You may justify incarcerating him forever. But what about the manager or the man who was doing a job? He is also huddled in the process. Auditor. What about them? And the second resolution, in my view, is pay up or remain in jail forever. You can't have it both ways. The moment you are granted bail, we all know, the system knows, the trial will not conclude in the next 100 years also. So it's as good as being declared innocent. So pay up, try and pay up, or remain in jail forever. So bail justice, I come back to from where I started. It's a complex area of the criminal justice system. Bail, not jail, jail, not bail. It's not bail, not jail, or jail, not bail, bail, not jail in some cases, and jail, not bail in some cases. It's not a one-way street. A coin has two sides. Now I come to another very interesting part of our discussion on bail justice. Satinder Kumar Antil's case, 2022. It's a landmark on bail justice. Please read this judgment. It's about 59-60 pages. Very well written. The whole law on bail is encapsulated in these 59-60 pages. Gudi Kanti Narsimulu, Guru Bachan Singh Sibia, all cases, all Article 21, liberty, bail not jail, jail not bail, economic offences, etc., etc. It's a wonderfully written judgment. I will run through some of the important aspects of this judgment. On page 1, the judgment starts with a beautiful quote on the importance of liberty. Liberty is one of the most essential requirements of the modern man. It is said to be the delicate fruit of a mature civilization. It is the very quintessence of civilized existence, an essential requirement of a modern man. John E.E.D. in Essays on Freedom and Power. Beautiful quote. Then the learned judges of the Supreme Court talk of the situation on the ground. Jails in India are flooded with under-trial prisoners. Of this category of prisoners, majority may not even be required to be arrested despite registration of a cognizable offence, being charged with offences punishable for 7 years or less. Very important. I have said in my book Chaff and Grain, Arnesh Kumar is not being applied. What happens is, when a man is arrested, the legality of the arrest gets lost in the maze of the criminal justice system. The focus of lawyers and judges shifts to bail. You go before a judge, अब arrest हो गया, तो now bail application बनाइए. The legality of the arrest gets lost. In my view, the legality of the arrest should be a factor while hearing the bail application also. And then the judges say, as observed by this court, this arrest, unjustified arrest, it certainly exhibits the mindset, a vestige of colonial India on the part of the investigating agency. I must add one thing to this. With all due respect to judges, there is an element of colonial mindset even in the judiciary. I must narrate this very interesting incident. When I was starting out, a retired judge told me, as a criminal lawyer, never raise your voice. Be as submissive as possible. Bail is discretion. A judge has 5 reasons to grant you bail and 5 to dismiss it. So you can't. So colonial mindset is there. Let's acknowledge it. Now, then the simple definition of bail is given. Then the principle that bail is the rule and jail is the exception has been well recognized through repetitive pronouncements of this court. This again is on the touchstone of Article 21 of the Constitution of India. However, I repeat, why doesn't it percolate into the criminal justice system? This principle of bail, not jail. We keep chanting it like a mantra. For 50 years we have been chanting this. It doesn't apply sometimes, at all levels. Still we follow that jail, not bail. Then the important part, I will come to one important aspect. You kindly go through this judgment. I am very happy that in this judgment, the Supreme Court has acknowledged a fault line in the judiciary. Very happy that there is acknowledgement. There is some judicial audit that has happened in this judgment. The judges say in para 67, the rate of conviction in criminal cases in India is abysmally low. It appears to us that this factor weighs on the mind of the court while deciding the bail applications in a negative sense. Courts tend to think that the possibility of a conviction being nearer to rarity, bail applications will have to be decided strictly, contrary to legal principles. We cannot mix up consideration of a bail application which is not punitive in nature with that of a possible adjudication by way of trial. On the contrary, an ultimate acquittal with continued custody would be a case of grave injustice. Many judges in the sessions courts feel the case will end in an acquittal. Witnesses will not come. They will not testify. They will turn hostile to the case of the prosecution. They will depose in favor of the accused. Ultimately, conviction to honi nahi hai. So, let me keep him in jail for as long as possible. Moral conviction, moral sentencing. So, at least there is an acknowledgement of this in this judgment. The judges do have a tendency to think like that. Now, this judgment has been highlighted in the media for the reason that towards the end of this judgment, the judges have said that like UK and some states in US and other countries, we must have a separate bail legislation in India. I do not agree with this at all. Bail justice must be left to the wisdom of judges. You cannot fossilize bail principles. You can't classify. You can't have a schedule. in that schedule where, offences are defined as cognizable, non-cognizable, bailable, non-bailable. You can't put another category. You can't say in murder cases after 50% of the evidence, he'll be eligible for bail. No. I'll tell you why. There are myriad types of cases. There are so many types of cases. Within a case, there are so many types of accused. As I said, in a murder case, suppose there was a law that in 302, forget bail for 3 years. Bail will be considered in the 5th year. What happens to the accused who are accused of exhortation? So within a case, there are so many dimensions. You can't equate cases. It has to be left to the discretion of judges. If you give too much leeway to the legislature, you may have a very strict bail legislation, twin conditions, etc., etc. Who knows? To check crime, heinous crimes. Certain offences may be classified as very heinous, and taking away the discretion of judges. I feel bail justice should be left to the wisdom of the judges. There may be aberrations, there may be inconsistencies. The judges have said, because there is a lot of inconsistency in the application of bail principles. So make a law. No. I would not want law to be formulated in pigeonholes insofar as grant of bail is concerned. It will be dangerous to fossilize and formulate bail justice into pigeonholes. I come to the last part. In my view, there are 4 pillars of democracy, in my view. 1, government of the people, by the people, for the people. In other words, elections. We elect our representatives. We, the people of India, elect our representatives to Parliament. The second pillar, the first is electoral democracy. Second, rule of law. We are governed by the rule of law, not rule of men. The third pillar, in my view, is freedom of speech and expression. Very important in a democracy. I must have a right to express myself freely, speak freely. And the fourth element, in my view, fourth pillar of democracy is liberty. Now, whenever there is an unjustified arrest or unjustified denial of bail, for that individual who suffers an unjustified arrest or an unjustified denial of bail, in my view, one pillar of democracy falls to the ground in his life, for him. It may not affect his neighbor, it may not affect me. So therefore, unjustified arrests and unjustified denial of bail, in my view, affect democracy. It's not simple case of criminal law, criminal justice, or CRPC. No, much more than that. I come to finally I must say, bail justice is a far cry in our criminal justice system. It's a far cry. Bail applications in certain high courts remain pending for years together, not months. In certain high courts of the country, bail applications do not get listed for the first time for months and up to 1 year. Bail justice is a far cry. We have miles to go before we can say that we have attained a level of bail justice in India. With this I conclude my talk today. Thank you for being patient. Thank you very much. Please.
Firstly, thank you so much, sir, for sharing your knowledge on this crucial topic. I'm sure everybody present here is going to take some very important insights on the concept of bail in Indian jurisprudence. It is my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this event see the light of the day. On behalf of everyone present here today, I extend my gratitude to our speaker, Senior Advocate Vivek Sood, sir, who spared time from his very busy schedule and to share his valuable insights on the topic today. I would also like to acknowledge the persistent effort of Mr. Anuj Chauhan, sir, and his team, including Mr. Anand and Mr. Gaurav, for organizing this event for all of us today. And last, but certainly not the least, my gratitude is presented to you all for being here today, without which this event could not have been possible. I thank you all, and as a closing segment, I invite you to join us for the high tea. Thank you.